Good afternoon. Welcome. I'm Rachelle Wilhite. I'm the designated broker and owner of Best Choice Realty. And I am very pleased to welcome Andrea to our Zoom meeting today. It's our Lunch and Learn series. We do these monthly at our office. And so it's a very relevant topic. I'm getting a lot of questions about handling listings that are estates, that are handling questions about before I list the property, what do I need to know about? And Andrea is going to cover a lot of those things on in our presentation today. So I would like to keep the questions to a minimum. You're welcome to continue to chat. We have allowed the chatting to happen. So if you do have a question while she's presenting, if you would be so kind to go ahead and just put it in the chat and we'll get to it at the end. And that will allow us to hear from Andrea. I've known Andrea for a few years, actually several. She worked under our attorney who is now a judge. Smith Alling is the attorney that I contracted with when I opened Best Choice Realty, and she was working under him for many years. And so she did a lot of the grunt work, all of the work that built Best Choice Realty. So Andrea comes with some great experience. And what's nice about Andrea is she transitioned out of doing more of the real estate, per se, brokerage management law into estate planning right about the same time that my father passed away. And then I was looking at redoing my living trust. So she did a fantastic job working with me and with my husband. So I highly endorse Andrea. If you're asking for a good estate planner, an attorney that I would trust, that would be the person I would recommend. So with that, I'll turn it right over to Andrea, and I'll control the questions on the side, Andrea. But if we need to open it up, we can certainly do that. It's up to you.
Sounds great. Thank you. Thank you, Rachelle. Thank you for the introduction. And thank you, everybody, for spending your time with me a little bit this afternoon. I'm just going to go through a little bit of, the goals for today. What are we doing? What are we talking about? I want to go through just starting off with what the basics are of estate planning. That's going to include what are the relevant documents, what are the terms that are used, what are the difference in the different fiduciary roles, what authority do people have in those roles, and what documents are we looking for, or how do we know what fiduciary role somebody is holding. And then I want to talk about, well, why do you care? What does this have to do between the intersection of estate planning and real estate transactions? So I'll just jump right into it. Off the top, what is estate planning? It's a lot of people, it's kind of a term that is thrown around that a lot of people don't know what it means. So I like to just define that from the beginning. It's the process of arranging your assets, ensuring their efficient management and distribution. It involves creating legal documents that empower others to manage your affairs on your behalf in accordance with what you want to have happen, whether it be with your assets or with your healthcare decisions. This includes managing your assets and your medical needs, and it can apply both while you are alive and after you pass away. I know a lot of times people run into somebody might be acting under a power of attorney where the person is still alive, but maybe they don't have the competency to carry out a transaction. Common myths in estate planning, that wills avoid probate. That's not true. A will has to go through the probate process. So I got, actually just last week, a realtor came to me saying that they got a client who has a will. Can they start selling the house? Well, no, we need to open the probate first. People think government will take my money. It's not true. There's a whole category of things that go into that. People feel like signing a power of attorney means I have no rights. No, you retain your rights, but signing a power of attorney allows somebody to also act on your behalf. Trust avoid taxes, maybe, but not always. Depends on what you're putting together. People think they're only for wealthy people. I'll tell you, in my line of work, wealthy is all relative. I've got people who have, what I would perceive as not much. They feel like they've got everything they need. People who have plenty feel like there's not enough. So you guys probably experience that as well in your line of work. People think estate plans were only for old people. No, they are for people with bodies, which means everybody. Your healthcare decisions are also needing to be made, and that can be done through your estate plan. The point of estate planning: clarity of who's in charge, address family dynamics, empower people to direct their own life, empower people to direct their own assets, asset protection, contingency planning. All of these things come into play when we're trying to, get an estate plan in place to make sure that we've got what we need handled. The 6 basic documents, and a lot of people know about these documents. It's your last will and testament. You've got your durable general power of attorney. And I'm going to go through some of these documents in more detail about how they work and what they do. Just going to give an outline here of what these documents are. Healthcare power of attorney, making healthcare decisions on your behalf. Mental health advance directive. Healthcare directive, and this healthcare directive is also known as your living will. It's making decisions on your behalf for end of life decisions. Do you want food and water? Those types of things. HIPAA form, who gets to access your healthcare information, and then maybe a 7th document. A lot of people know that Washington is a community property state. What does that mean? Well, we, can sign a community property agreement that makes our assets more easily transferable when we pass away, but there's a process to that. A couple other tools that we use are, trusts. People hear about trusts. There's a lot of different types of trusts. There's testamentary trusts, revocable living trusts, irrevocable trusts, special needs trusts, children's trusts, credit shelter trusts, all these different types of trusts that overlap with each other. I'm not going to get into the details of these, but just know there are a lot of different types of trusts that can come into play that you're going to run across. Other estate planning tools are real estate deeds. You guys know those. You should be, very familiar with those. It's more of the titling on the deed. Is it tenants in common, jointly with right of survivorship, transfer on death deed? Those things matter. Other types of tools: creating an LLC, account titling, and beneficiary designations. Maybe you have a life insurance policy and you've designated a beneficiary. So now I want to take a little bit to go in to talk about some of the specific documents that you're going to run into, or that people have when they create an estate plan. There's your last will and testament. Most people know, what that is, what that's all about. It establishes who gets your assets when you die. It can be changed while you're alive. It doesn't matter if somebody has a will in place that names, their daughter or their son or their whoever as their power or as their personal representative. If they're still alive, that personal representative has no power. It identifies who is in charge. That person is called the personal representative. In order to put a will together, there's a couple of requirements. You have to be over 18, you have to be alive, you have to be competent. I have somebody that, came to me about 2 months ago. Mom never put a will together. We all knew what she wanted, but she never put a will together. If she's passed away, there's no making a will now that she's passed. It can be changed as many times as you want, so long as you're competent. That's another thing that, some people get surprised about. They think it's in place and they can't change it. So, what are they going to do if their kid who they chose has now passed away, or whatever outcome they're looking for, it doesn't make sense anymore? No big deal. We can change your will. It does not come into effect until you die. That's where it matters. If somebody's trying to act as personal representative or as executor, and mom or dad or whoever is still alive, they have no authority to be doing anything. It also needs to have been entered into probate. Your will is just your set of instructions to the world that has no power until the document has actually been entered into the probate process. Another document you're going to see is trusts. I'm not going to go into all the different types of trusts, but they all have some pretty common elements. It establishes either who gets your assets when you die, or controls management of your assets while you are still alive. And so people will create a trust, and you are likely to run into this a lot, where their house is owned by the trust. It's the trustee who's going to be able to act on behalf of the trust, and the trust is a separate entity that does own those assets. It identifies who's in charge. Under a trust document or a trust entity, it's the trustee that is in charge. Some people will confuse personal representative, executor, trustee. Those are not the same. It's the trustee who acts under the terms of a trust. Same thing, you have to be over 18, alive and competent to create a trust. The ability to change the terms of the trust really depend on the type of trust that it is. I've got, people will come in and they'll say they want to have a different trustee or they want to have a different outcome. And that depends on if it's revocable or irrevocable. And however, changing the terms of the trust is different than changing the assets of the trust. Just because a trust might be irrevocable, it does not mean you can't sell the assets of the trust. In other words, if we have an irrevocable trust that that names, trustee and who's going to get the stuff and how it should be managed, that owns a piece of property, that property can still be sold or future properties can still be purchased. Changing the assets of the trust does not actually change the terms of the trust. It just changes, what the trust owns. It's effective upon creation unless it's testamentary, and that's where people will have a trust sometimes created for their kid or some other person in their will. If it's not testamentary, it's usually effective upon creation. More details, trusts are a separate entity like an LLC or like a corporation. They are not, they're separate from the person. They must be funded, meaning some asset must be transferred into the trust, whether it be real estate, accounts, something must actually fund the trust for it to come into existence. They do not go through the probate process. That is a process, that is a way to avoid probate. A will must go through probate, a trust not necessarily. They're great for people with out-of-state properties. They are a more private process because they don't go through the probate process. You should have a pour-over will if you're going to have a trust. And that's in case a pour-over will is basically a will that says, take everything I have and give it to my trust. That is in the event, and this is something you guys likely run into. Somebody is going to, let's say they have real estate in their trust, and then they sell that real estate. If they buy a replacement property, but they do not buy that replacement property in the name of their trust, they're at risk that when they ultimately pass away, if that replacement property is not owned by the trust, that property is then going to have to go through the probate process. That can become a big issue if somebody purchases a property, does not put it in their trust, and then does not have a will. Then what happens is we're going under the intestate statute, which might not match or have the same outcome as what somebody had intended under the terms of their trust. And it can be a big issue for people who, just if you see a house being sold by a trust, make sure that if they're buying a replacement, confirm if they want that replacement to also be owned by their trust. Power of attorney, that's the name of the document. It controls management of assets that are owned by the person, not by a trust. So we sometimes run into that where somebody has a power of attorney in place and then they also have a trust in place. But there's a common example is we've got daughter is named as under the power of attorney, but daughter is not named as trustee. Can daughter help mom sell the house? Well, no, because the house is owned by the trust. So only the trustee can act on behalf of the trust. Power of attorney is only for assets that are owned by the person, not by the trust. And it's also for while you're alive. It is not effective after somebody passes away. You need to, if somebody has passed away, then we're looking at either the probate process with their will or the trust if the asset's owned by the trust. Your power of attorney has no effect after you pass away. It identifies who's in charge. The actual term under a power of attorney for the person in charge is the attorney in fact. Most people do not say attorney in fact. Most people just say power of attorney. That is a well-used term. Everybody just uses it wrong, and that's totally fine. Just know that attorney in fact is the actual name for the person named under a power of attorney. Same thing, over 18, alive, competent. It can be changed as many times as you want. And it's effective based on its terms. It's best if it's effective upon signing. Sometimes it's effective upon incapacity. So if somebody is acting under a power of attorney, make sure that the terms allow that person to act, that the triggering event has occurred. So for example, if it says my power of attorney is effective after 2 doctors say I have lost competency, you need 2 doctors' notes saying that before you can act under that power of attorney. I do not favor those because it's hard to get 2 doctors to say that. It's better to just have it effective immediately. They're flexible in the authority that they provide. So depending on what it says, that's what authority the person has.
Before you go to the next slide, Andrea, so I get this question a lot. Is it okay to sign on the power of attorneys? We do a lot of POAs, but I've always advised that they sign attorney in fact. If you were to see something, a document that has POA, does that make it not enforceable, or there have been challenges in the past?
That's a really good question. It is best to have it be attorney in fact or AIF. It
Okay.
is okay if it says POA. That's not going to be deadly. That's not going to throw it out. But
Okay.
it's better to just be correct.
Okay.
Because POA is used so often, the argument could be, well, I meant under POA, so under the document, which is called the power of attorney. But you are right. It is best to be attorney in fact or AIF.
Okay. Thank you so much.
Yep. So now I'm going to kind of just go into what the fiduciary roles are. And we've touched on them. I just talked about the documents. The fiduciary roles are the people that are, named under the documents. So personal representative. Another word for personal representative is executor or executrix. That's somebody that's named in a will. Those are old, archaic terms that we don't really use anymore, but people use them in conversation. Administrator is the term that is used if there is no will, then the term is administrator. All of these, executor, executrix, administrator, are under the umbrella of personal representative. That's who acts under the terms of the will. Person named in the will or named by statute if there is no will. The state has decided, who you probably would have wanted to name, who you probably would have wanted your stuff to go to under the intestacy statute. So that will kick in if there is no will. There's no authority for the personal representative to act until after the testator has died, and after actually appointed by the court in the probate process. A person, if mom or dad or whoever is still alive, the executor or the personal representative has no authority to be actually acting to sell houses or to do things on behalf of the testator, of the person who it belongs to. For the role of trustee, that's somebody that's in a trust instrument. That authority comes into play once the role is accepted or assumed. So that is different than a will. Will has to go through probate. Trust does not. The trustee can just come into power as soon as the triggering event occurs. It can be while the trustor. So if I always do like the mom-daughter example or mom-son example. If mom is still alive and is named their child as the trustee, mom can step aside, or mom can say, come join me as a co-trustee, and they can still act on behalf of the trust, even if mom is still alive or the trustor is still alive. It's whatever the trust says is what they're supposed to do. Sometimes the trust says, give everything, after I've passed away, give it away immediately, sell the house or do what they need to do. Sometimes the trust says, let daughter or let husband or let whoever live in the house for a set number of years for the rest of their life. Whatever the trust says is what they have the authority to do. For the attorney in fact, that's person named under the power of attorney. Like we talked about, most people say power of attorney. It's common enough. Attorney in fact is correct though. The authority begins whenever the power of attorney says it begins. It can either be immediately, which is preferred, or on a triggering event, which is obviously not preferred, because when somebody goes to use a power of attorney, it's usually because it's an emergency and we don't want to have to jump through hoops to get things to go through. There's no authority again after the person passes away. And I had this happen where we were selling a house and person passed away. we were going to use a power of attorney, but then person passed away. We cannot go forward. Power of attorney has no power after the person passes away. Now I want to kind of go into, kind of what the estate administration, the probate process, what that looks like when somebody passes away. So somebody dies, now what are we going to do? First questions are always, what are the assets? How are the assets titled? Are they owned by the person? Are they owned by a trust? Are they co-owned jointly with right of survivorship? How are the assets actually titled? What documents are in place? Is there a will? Is there a trust? Are there deeds, like a transfer and death deed, something in place when, for the assets? Who's in charge and under what authority? Again, is there a trust? So then it would be the trustee, or is there a will? So then we're looking at probating the will, getting a personal representative appointed. What authority do we have now that the person has passed away? The trust and
That's
estate.
great. That was a great slide too. I mean, for agents to really, because we hear about it sometimes, we don't want to be ambulance chasers,
Yeah.
right, Andrea? But sometimes you just need to know what to say, right?
What
And
do I
so
do?
these
Yeah.
questions that I would jot down. When somebody does pass away, you're going to want to ask some questions to figure out what they have in place.
Yes. Yeah.
Sorry to interrupt.
Yeah, no, totally. And so then what's the process? This is your I always like to break things 1, 2, 3. You got 3 steps. So when somebody passes away, whether they have a will, whether they do not have a will and they have nothing, or they have a trust, the process is generally the same. Number 1, we're going to collect the assets, and it can be figurative, right? We're not collecting a house. We're going to collect the assets, figure out what they are. What does this person actually have? Number 2, we're going to pay off the debts and address the taxes. The debts being, last illness, funeral expenses, utilities on the house, any final payments for anything, any credit card debts, the mortgage, if there's a house, the mortgage obviously needs to be addressed. Typically, if the house is sold, that's going to be addressed at closing, all of that. You use the person's assets to pay off the debts. Then at the end, after creditors have been made whole, we figure out what's what. Then you distribute the assets, and you distribute the assets according to either the intestate statute, the will, or the trust. Whatever is controlling the outcome determines how the assets are distributed. Couple pieces that go into this. There is, it's the small estate affidavit process. You guys probably do not run into that because this is not really allowed when there's real estate involved. So you naturally wouldn't have to worry about this piece of it. The small estate affidavit is when somebody owns or has in assets in total $100,000 worth of assets or less. That's usually if somebody's got like a bank account or two and maybe a car and some stuff. We don't need to go through the whole probate process to deal with that. But if there's real estate involved or the assets in all combined assets exceed $100,000, we're not using the small estate affidavit. Beneficiary designation, very common in retirement plans, IRAs, 401ks, or life insurance policies, annuities. People will put their beneficiary designation down. That's who's receiving that asset. It is not necessarily the same person that's going to receive the house. It's whatever you put on those account designations, that's who's getting it. The house is going to go based on either the probate process or what the trust says. And then you're looking at, either or a probate might be what you're doing, or trust administration. Probate is for assets that are owned by the person that do not have beneficiary designations or some other way to get out of that person's ownership. Trust administration comes in when there's a trust. So either it's a trust that gets created under the will, or it's a trust that was created during the person's lifetime. Probate process is the first thing you do, you're petitioning the court for appointment of the personal representative. If there's a will, we ask the court to admit the will to probate. The court will take a look at that, make sure it's in fact, the original will and signed by the person, witnessed by 2 people. It should be uninterested people. There's issues that come up if the witness is also going to receive under the will that looks a little shady. There's issues that come up with that. But we ask the court to admit the will into probate. And then the court issues what's called letters testamentary or letters of administration. This is the golden ticket. This is what I call, the keys to the kingdom. This is the keys to the house. Letters testamentary comes in if there is a will. Letters of administration come in if there is no will. The power is the same. The court will issue it, and it's when you're going to see it from your clients, it's a purple, well, in Pierce County at least, it's like a purple document that just says so and so is appointed, and it looks on court paper. That's the key. That's what they need. That proves their authority. Then we send out creditor notices and statutory notices. We let anybody out in the world. We publish in the newspaper. It's really archaic. Nobody reads the newspaper, but that's the law. If you have any claims against this person, come make your claims now. You have 4 months to make your claim. Statutory notices are, we let anybody who would be entitled to the estate know that there's something here. We're opening a probate. Pay attention because you might be entitled to something. And then we liquidate and consolidate the assets, pay debts, including creditor claims that came in during the creditor notice period. We address the taxes, distribute the assets according to the will. And then at the very end, we let the court know, hey, we're done. We've done everything we need to do here. File a declaration of completion. That is, in a nutshell, the probate process. The time that it takes is a couple things that can, throw clients off a little bit on this one is the creditor notice period. It is 4 months. It's the 4-month clock starts when the notice is actually published in the newspaper. The notice does not get published till the person's actually appointed. And so there's a couple of steps to jump through. Question I get all the time that I'm sure you guys get all the time is, when can I sell the house? Do I have to wait for the creditor notice period to pass before I can actually list the house and sell the house? The answer to that question is no. You do not have to wait. You can start the process of liquidating the assets. That is okay to do so long as there's no controversy or claim of, somebody saying that I own the house or I want the house, and if everybody's on board that the house can be sold, you don't have to wait for the creditor's claims period. You can start liquidating the assets, selling the house, but what you cannot do is distribute the money that came in. So you're taking one asset, house, turning it into another asset, cash, but you are continuing the ownership of the value to be owned by the estate until creditors are made whole, taxes are addressed, and then you can distribute after that. And the other thing that comes up is the taxes. You always, just like, all of us have to file taxes by April 15th. So does the person that passed away. So that's another thing that holds up the timing of a probate administration, but you can still do what you need to do liquidating the assets. Trust administration, very similar process. The trustee just accepts the role as trustee. They do not have to actually go through probate or anything like that. They just come in and they're the trustee. There's they can send creditor notices if they want to, if there's concerns that this person that passed away might have somebody out there in the world that has claims against them, that they had some debts. They can, if they want to, send notices out. It's not required. I have situations where they say, I want to do that. Grandpa was involved in some gambling. I just want to cut off anything, that might come out. Notify beneficiaries, just the same. Hey, you might have a claim here to some money. Here's what the terms say, and here's what we're going to do. Going back to the same steps: liquidate the assets, consolidate the assets, pay any debts, address the taxes, distribute the assets, or manage the assets. If it's a situation, very common if we have, children, or maybe they're not children, but they're people who are young, like early 20s. It might be that we're holding on to the assets until that person is of the age that the person who died said is appropriate, according to the terms of the trust. So another thing that comes up, the person is still alive, but they're not doing well. So same questions. Well, what are the assets? How are the assets titled? What documents are in place? Do we have a power of attorney or a trust? Who's in charge? Under what authority? Do the documents need to be updated? If yes, in that situation, do we have a power of attorney that says it's not actually doesn't come into existence or power until the person loses competency or has a disability? Well, maybe we just update that power of attorney. If there's still competence and ability to update, maybe we update that power of attorney now while we can, so that if an emergency or something comes up, we're not stuck with that old power of attorney. Other stuff, update the estate plan if needed, same issues. Establish the authority for somebody else to act if the person's not doing well. Do we have a power of attorney? Do we have a trust? Should we get that in place? Confirm beneficiary designations on the accounts while we can, right? And then find out, do we need Medicaid? Do we need long-term care costs to be covered? Are we going into an adult family home? How are we paying for that? All of those issues come into play. One piece on the Medicaid, I don't think we'll have time to get into this today. Just something that comes up though is somebody being able to qualify for Medicaid. And if you find that somebody is selling their house because they need to pay for long-term care costs, if they are married, there's options for them to be able to keep that house, get the person who needs, long-term care into an adult family home, get them on Medicaid, then sell that house out of the spouse's name. That is a way to keep, keep everything. Another thing that comes up is people think, I'm going to lose my house. You will not lose your house. You can still get on Medicaid, but Medicaid can get a lien against the house for the person who's on Medicaid. If you put the house in your spouse's name, they are not the person on Medicaid. So that is a way around all of this. Just, there's a lot more that goes into that, but if you've got somebody with some potential Medicaid needs, there's ways to save the house or save the proceeds of the house if they have a spouse.
So we're just doing quick claim at that point, just quick claiming the other spouse off.
Yep, quick claim to the spouse, and then depending on what they have going on, wait till they get on Medicaid and then sell the house.
Gotcha.
So gotta get into kind of the intersection. I mean, a lot of this already kind of overlaps here, but a big piece of this is going to be the title and the deeds, the to the property, how it's actually owned. And then of course, always estate taxes come into play and the impact of that. So the title and deed implications, there's a couple. Let me see where I'm at for time here and how much I'm going to need here. So, okay, got a few good amount of time.
Well, before you go to the next one, would irrevocable trust help in that case? If that people that in that scenario you gave?
The Medicaid scenario?
Yeah, would the
Probably
irrevocable trust?
no.
No?
So so Medicaid is really complicated. That has all these rules. The big picture is if you put your asset into an irrevocable trust, it could be considered a gift. And then it hits the 5-year look back period and it get penalized for doing that gifting. The trust itself has to be a qualifying type of trust in order for it to not be continued an available resource.
Okay.
The person going on to Medicaid can only have $2,000 of counted assets. $2,000 is not like nothing, which is why I say don't sell the house, because the house is not counted toward that $2,000. Because if you sell the house, now it becomes counted. There's all these things that go into it.
Gotcha.
In the ability to save the house, just let me know if something like this comes up.
Okay.
I can walk through it.
All
But
right.
I like to flag it for people. Medicaid is another world. So the title and the deeds, a couple things you're going to run into: joint tenancy with right of survivorship, tenants in common, community property, it's owned by a trust, or a transfer and death deed. Joint tenancy with right of survivorship, that's where the co-owners jointly own the property while everybody is alive. As each of them, pass away, then their share is transferred to the living co-owner, so the survivors of the owners, right? Last one standing takes all. So whether it be 2, 3, 4, however many people own it, they continue to dwindle down. Last one standing takes all on that ownership. I want to go back to this a little bit. So what happens on this is, so if we've got like a group of siblings, let's say you've got 3 people, 2 have passed away. The third one is the survivor. The third one then gets to say what happens to it. So if they say it goes to my kids, that's their business. They can do that. So sometimes that works. Sometimes it does not work to have jointly with right of survivorship. And then tenants in common, where co-owners, again, they jointly own the property while they're living. When the owner dies, their share transfers, via the probate process. So for two siblings that own a piece of property, let's say one sibling passes away, that sibling's half, they get to say what they want to have happen with that. They get to say, I want to give it to my kids. I want to give it to my spouse. I wanted to, maybe they give it to their sibling, but they don't have to. They get to direct what happens when they die. It could result in multiple owners and disputes. You could end up with, aunts owning it with nieces and nephews. You could end up with a bunch of cousins owning property. It is what it is. For community property, Washington is a community property state. Assets acquired during marriage are presumed to be community. They are not necessarily community, but that's the presumption. Each spouse gets to direct what happens to their half. People are always surprised by this. You can disinherit your spouse. If you do, then there's protections for your spouse to come in and force a share of the estate, a share of the assets in order to keep them supported through their lifetime. But you get to direct what happens to your half. What that means is it's not automatic that your half goes to your surviving spouse. There's a couple of things that come into place. Most people like the person they're married to, want them to have their stuff. But there are situations where somebody gets into a marriage, it's usually later in life marriages, very common. I'm gonna just make up a story. Well, it's actually happens all the time. They get married when they're 65, they had a whole life before they met. They each have their own kids. It was the family home. They raised their kids there. They want their spouse to be able to live there, but they don't necessarily want their spouse to take the whole, family home. They're going to not give it to their spouse. So upon the death of the first, like I said, they don't automatically get it. Just a couple things that need to be filed after that. When the property is owned by a trust, the trust is a separate entity that owns the property. So the person passes away, the trust did not pass away. The property continues to be owned by the trust. Titling, you're going to see it written as trustee of the XYZ trust. You might see under UTD for uniform trust date or the under agreement, and it's the date formed. It's a common titling. When the trustor dies, still owned by the trust will direct what happens with the assets. Additional things. The trustee has the authority over the trust assets, not the attorney in fact under the power of attorney, not the personal representative. It is the trustee that has the authority. It's not always the same trustee as the person named on the vesting deed. Very common if, the example of parent creates a trust, parent passes away, child comes in and is the acting trustee. The deed is going to say in the name of the parent as trustee of the trust. We've got a new trustee. Always make sure that the person who's acting as the trustee is in fact the trustee. It's not always going to be the same person that's under the deed. The flip side of that is, and we've had this come up where we've got a parent who was the original creator of the trust. They were the original trustee. They've got some capacity issues. They go to try to sell their own house. Somebody's taking advantage of them. They're no longer the acting trustee. They've already stepped down. And so even though the vesting deed says, dad as trustee of dad's trust, dad is no longer the trustee and has no authority. The kid is the acting trustee in that, in that scenario. We've had this come up, so I like to just flag it. Sale proceeds issued in the name of the trust. This one I've seen an issue where people can't get this. The sale closes and then they're surprised that they actually need an account that's owned by the trust. So just in preparation of that, if you see you're selling a trust property, make sure that your client knows we need an account to deposit this money. So go make sure you have an account that's actually owned by the trust. If they're buying a replacement property, we talked about this a little bit. Consider if the replacement property should be owned by the trust as well. If you're downsizing, or whatever they're doing, you don't want a situation where somebody properly created their estate and then did not have a follow-up property owned by the trust, and then it goes under the intestate statute, and it's a mess. Sometimes you need a certificate of trust in order to get the sale to go through. Title company usually will tell you. Transfer and death deeds, like it sounds, when an owner passes away, automatically invests into the name of the person that's named. Passes outside the will, meaning it passes outside of probate too. The vesting is automatic. It is revocable until the person passes away. Even if it doesn't say it's revocable, the law says it's revocable. The downside is no contingency planning allowed. So if you say transfer on death, to my 2 kids to share and share alike, that's great. What if one of your kids passes away before you though? And you would have preferred that that child's half goes to your grandchildren of that child, right? It goes to that kid's children. You cannot do that under a transfer on death deed. What's going to happen is you're going to say to my 2 kids, one of them passes away, the survivor takes all. The one that passed away, their line is entirely cut out. That's what kind of creates disputes that we deal with. The other issue that comes up with transfer on death deeds is there is now a case from the East Coast that is it was held up and it was fine, it was allowed, that the insurance company, the property insurance dropped property insurance immediately on the death of the person that passed away. So what happened in that scenario was person had transfer on death deed, they die, there was a fire 2 weeks later, the property insurance company said, too bad, we do not have to extend insurance because you had a transfer on death deed. And so there was an issue for the family. So just caution if people are asking you or you're trying to put together transfer on death deeds, there's a couple of issues that can come with that. Tax issues, just to know, Washington's estate tax limit is 2.193 million. There are implications if somebody is above that. If most people's assets, their biggest asset is their house. And so if you see people who have assets that are nearing or above that limit, talk to them about, hey, maybe you should do some tax planning, estate tax planning. That's all you really need to know. The federal tax limit is much higher. Right now it's 13.6 million, less of an issue. Capital gains taxes also come into play. When somebody is about to, if the quick and dirty on this is, when somebody sells their house, if it's their primary residence, they can get the primary residence exemption for the purpose of capital gains. Either way, when the person passes away, there is a step up in basis. So somebody came into my office yesterday, they bought their house for $13,000. They're the winner so far, the lowest number. It's now worth $600,000. That gain, if they sold the house today for $600,000, that gain of that 600,000, minus that 13,000 is going to be a lot. They can take that 250 off the top, but they're still paying a pretty hefty capital gains. This person is 84. Why are they selling their house? So the advice to them is just wait till you pass away. Then your heir, your kids, are going to get all of that equity tax-free. You get that step up in basis instead of the basis being that 13,000 that he bought it for. The basis will be the value as of the day that he passes away. Something to consider if you've got people who are selling a house and they're clearly gonna, if you just wait a few years longer, it comes up. I wanted to flag it for you. Your role, in this process, just really spot the issues as things come up, ask the questions, educate the clients as much as you feel like you can, and then just connect them with an accountant or an attorney or just whoever makes sense, that they might need in their corner to get them through their specific situation. And what I find a lot of times is real estate agents are like the first line of defense. The first thing is, they're calling you guys, they're having issues come up, they're trying to figure out who's in charge, how do we do this, how can we help mom, or how can we get our stuff set up, or it's an investor who's buying a bunch of properties left and right and they're doing all this stuff, but they don't have anything in place to protect their assets. So just paying attention to sort of what's going on for them, and that can provide them the value, to make sure that they get what they need. I wanted to stop here to see, I've got a couple of examples in here for things that, just a couple of case examples of just some real scenarios that I've experienced. But I wanted to open it for questions if anybody has questions before I start jumping into.
And we might have some real live ones for you. There's a couple I've dealt with. First, before we go into Q&A though, Smith Alling was an excellent law firm. We've already got a few people that have messaged me by text and also on the chat. Is is there somebody else in your law firm that handles the estate planning? Russell Knight, for example, is he still with Smith Alling, or is that?
Yeah, so he is still here. So specifically in this office, we have we have 11 attorneys. 2 of them are associates. The rest of us are the shareholders. We have 2 of us who do estate planning. It's myself and Nicole Hancock. I specialize in Medicaid as well. Nicole specializes in guardianship. So that's kind of where we break off.
Okay.
Russell Knight, he does do a little bit of, like on the side of estate planning. His primary focus is actually litigation. The rest of them, we've got 2 that do family law. So if you've got some family law issues, we can, deal with that there. The rest of them do general litigation. We've got real estate disputes, property line disputes. If we have a trust and estate dispute, we've got people here that do that as well.
Great. And then average cost to set up a will or a trust?
The average cost for setting up a will package that does not include, a trust is it's anywhere from $2,000 to $2,500 for a full plan for a basic will plan. If you're adding trusts into it, like trusts for your children or things like that, that are going to be built into your will, that price is going to go up just a little bit, probably around closer to $3,000. If you're having a full estate plan that includes a trust, you're having a full trust package done, those start around $4,500 and can go up from there depending on what your needs are. If it's a pretty basic situation, usually $4,500 plus recording fees. So however many properties you have is how that's going to cost. And then,
Okay.
Yep.
Perfect. And then who do you petition who can petition the probate court? I think is the question. That's a question that came through. Are you able to answer that one?
Yeah, that's a really good question. So if there's a will, the person named in the will is entitled to be the one to petition. They've got 40 days to do it. If the person named in the will kind of sits on their rights and doesn't get around to doing it, which happens, then the intestate statute kicks in, and then you're looking at next of kin in the order listed. So it's first spouse, then kids, then grandkids, then siblings, parents, just in the order of a relationship, or creditors. If creditors can also come in and say, we're going to open this probate and we're going to force it through, we're going to get our money. If that happens, the person that's named in the will, the court is pretty generous about, unless there's they were really negligent and there's a reason not for them to be the one named, then they can usually come in and ask the court, hey, can you follow the terms of the will? If there is no will, then we're just under the intestate statute in that same order: spouse, then kids, then down from there.
Okay. And then another question. I don't know if somebody jumped in late. Anyone have a good recommendation for probate attorneys in Washington? So you're a probate attorney.
I do probates as well. Yep. So I do probates and I do trust administration. So we do that here in Washington. It doesn't matter where the person died. As long as they died in Washington, you can open a probate in any county. So sometimes if you've got somebody that passed away, in a different county or kind of far away, and the personal representative is here, then we'll just open it here.
Yeah. So Kim, that's my recommendation. It's Andrea. I don't know if you jumped on early, but I gave her a raving recommendation. She took my situation, and I did use a different attorney that has been around a long time for my father's. But for mine, I'm looking for somebody that obviously knows the law very well. And Andrea's done a great job with helping me build my business. And when she trans over to estate planning, it was definitely the right move to go ahead and continue my business with her. So I continue to recommend Andrea that's doing our presentation today as the probate or estate planning attorney.
Thank you, Rachelle. And then another thing I just want to put out there, I did, while I was helping Rachelle, what I was also doing a lot of trust and estate litigation. So I've litigated these issues. I see what happens if it goes bad. So with that, then I'm able to kind of prevent that going ahead. And I decided I don't like doing that part of it. I like the planning, stopping it before it starts.
I will say Andrea's very personable. When I met with her, my husband is not, and some of you know Eric well. we have different way of looking at our lives and our estate. And so it was interesting to see how Andrea was able to navigate between two personality types. You probably remember that. That was
Happens
interesting.
all the time.
Yeah. So I did enjoy our experience there.
Thank you.
Let's go ahead and open up. I think a couple of you had some scenario questions. If you want to unmute your line, you're welcome to do that.
May I?
Yes, go ahead.
Okay, that's my personal situation. Kate here. Hello.
Hello.
All right, so my mom and I are on the title of her paid out house, paid off. She otherwise makes a little money because she didn't work in America long enough, and therefore she's eligible for the in-home care. She's getting older. She's 75, and I was hoping that someone could come in and help her around the house, you know, like remind her,
Yeah.
take medications, pretty common stuff.
Yeah.
I'm just clarifying. You're probably going to say the same thing as about Medicare, but still. So again, 50-50 on the title. Now you said that we can transfer. I mean, she can do the quit claim deed to my name,
If
but
it was a spouse, quit claim to only a spouse.
oh,
free-
okay, so
free
that would
transfers between spouses is not free outside of that.
Okay.
There are certain exceptions. If you do a transfer to your child, there's certain exceptions that are allowed. What it primarily is if it's pretty rare that it actually applies though. Like it has to be a disabled child, child under 21. There's a few exceptions that apply. Generally, you can't really transfer without exchanging value to anybody except your spouse.
No. What I'm trying to ask is if that's why I asked that other questions about irrevocable trust. If she creates one, and so there are two different programs helping elderly to care for themselves at home. One has it's very limited. It's only 20 hours per month, and the other one is full program. So I'm trying to put her in a full program because of the range of diseases she has.
Mhm.
But the full program says that they can go after estate after she passes.
That's exactly right. They will go after her share of the house, not your share, but her share.
Okay, unless she.
If she gifts it to you, it's going to disqualify her for 5 years.
Yes, that's
potentially 5 years.
that's what that's what I've heard, that at
Yeah.
least 5 years she would have to wait until.
Yeah.
Okay. So no trust would help in this case, right?
No.
Okay.
Not
All right, thank you. That's all.
Question, thank you, Kate. Other questions?
Yeah, can I chime in?
Go ahead.
So I'm Kim Vickers, and I want to clarify why I was paying attention. And but I thought I'm familiar with estate planning. And so I guess where I was confused with the talking about her experience with estate planning, I didn't see it as hand in hand with probate. I say probate is different than estate planning. So when you guys, with your experience, Andrea, you're actually doing both, right?
That's
So I
correct.
was separating them, and I heard litigation and I heard estate
Yes.
planning. I was trying to key in on probate, and
What do I actually
that's
do?
where, what's that?
Like, what do I actually do?
Yeah.
So what I was saying is for several years when I first started practicing, I did do litigation. I do not do that anymore. I focus on estate planning, elder law, and probates and trust administration.
Okay,
From my perspective, they go hand in hand in the sense that if I'm going to put a will together for somebody or put a trust together for somebody, and then they pass away, their loved ones are going to come to me and say, you know, hey, we did this. Now what? Where do we go from here? So I help them through that process as well.
okay, wonderful. So you'll have your contact information provided to us, right? All right, thank
We'll
you so
provide that.
much.
Thanks,
Thank
Kim,
you.
for clarifying.
Super.
Yeah, okay, so yeah,
ahead.
I have a few questions here. Thanks for the info, Andrea. It's really helpful. So if so the executor of the will is the one that have the final say on what to do with the asset,
Not
if there's
exactly.
a dispute among brothers and sisters.
The will itself says what's supposed to happen, right? The person representative or the executor doesn't get to say, well, this makes more sense. Let's do it this way. If they have to follow what the will says. If the
Okay.
will is silent on a certain thing, then the person representative has the authority to, make decisions one way or the other, depending on what that scenario is there. I would recommend often it's best to just do a motion to the court, a motion for instruction. And that's where we have the court make a decision of what's what, because we never want it to come back on that person representative for making a decision that then the beneficiaries say was a breach of their duties. So
Hmm.
it depends. It depends on the situation.
If it's
Okay.
getting kind of out of hand, Tyler, it sounds like you do want to involve an attorney.
Okay.
Yeah.
And so, no, not the scenario I was talking about is not out of hand. It just was curious. So, now the process is, so as an agent, you just list the house regularly, and then when there's a sales coming in, is the person who already been, let's say the executor, decide on accepting the offer or not, and then you just pass it on to the attorney, or the attorney only involved after the sale is done?
It depends on that specific probate. So there's a couple situations. The person representative, they have a duty to get the highest and best price or the fair market value and blah blah blah. Generally, then it's pretty straightforward. If you list it out in the open market, name it's the estate of, right, that's selling it. The estate of whoever is the seller. Person representative is the person that can sign on behalf of the estate. There are situations that come up where there is a dispute where people say, the family or whoever gets to have an opinion might say that this house is worth a lot more than what you're selling it for, or there might be some claims against it. So there are situations where we have to actually get court permission first. Again, that's motion for instruction where we ask the court, hey, do we have authority to sell this house if so long as we get an offer that's above X price. That comes up. So I don't want to give a blanket rule of, the court does not have to be involved. Sometimes it comes up. For the most part, though, the person representative can just go forward, hire their agent, whoever they want, get the house sold. So long as everything's on the up and up and they're not doing any, shady things where it's a discount price to a buddy or anything like that.
Okay. So if let's say there's a probate going on, if I want to make sure that I can list the house, should I talk with the probate attorney to make sure everything is on the up and up for me to list that property, or should I trust my client who say, yeah, it's okay, he's the executor and all of that?
On your hand, what you want to make sure of, it's kind of up to you. If you feel like the person, if they don't feel like they're on the up and up, then obviously you might want to check with somebody on it. Or if they just don't kind of understand what's going on, the things that you're going to be looking for is letters testamentary or letters of administration. I would suggest ask them to give you that.
Okay.
That is the proof. If somebody has that in hand, that tells you that they've already petitioned the court has already appointed them and given them the power to move forward.
I see. Okay.
Okay, and
then,
I'll tell you, as many times as I explain to people, here's what's what, their relative or their whoever just died, right? They're grieving. They don't understand most of what I said, they're understanding it, but it's kind of complicated. So they might really believe they have the authority, but they don't have it yet. So just, that's kind of what I would suggest.
Great idea.
Okay.
Thanks, Tyler, for the questions. We're right almost at the 1 o'clock, so I just wanted to keep an interest of time. So Andrea,
I have a question.
Go ahead, Patty.
Okay, I'm dealing with a situation where a lady was raised in an orphanage, never married, no children. We're trying to track down any potential relatives through the files of the orphanage if they'll open them. So in this state, if you leave a property without somebody inside, eventually it gets broken into. That's just the reality of what happens.
Yeah.
So where do we stand in terms of moving forward? A, to legally get on the premises of the property, and then B, we do have a foundation. We want to set up a foundation in the name of the property. So can we do that?
Oh, so I just actually spent this morning researching all about when your assets is sheet to the state, meaning you have no relatives. So this is really, really timely. Couple things on who can be in charge is it depends. If there's no relatives, is there a will?
No will,
No
right?
will
Well,
and no relatives?
No will, no
none that we can
relation.
find yet.
Who's then it would go to the state of Washington, and so it would be their problem. Yeah, it's not ideal, but it's their problem, right? So then what you would do is you notify the state of Washington that this property exists, and then it'd be up to them to open a probate and have the control over whatever happens with the property. Who is it that's wanting to do a foundation? It doesn't, I mean, what I'm hearing, it doesn't sound like they have the authority to do that.
They have to be through a power of attorney to set up a foundation.
If
Uh,
it's the power of attorney has no power once the person has died. So
that's
has the
true.
person
That's
died
true.
yet?
Yeah, the person died.
If the
And
person,
so,
yeah, if the person's dead, it's over. There's nothing anybody can do. If there's no will, we can't create one after the fact. Then it's the intestate statute. The intestate statute says it goes to the family members as far out as cousins. If there are none, it goes to the state of Washington. Somebody can notify the state of Washington. There's a form, that you can, it's a one-page form. You notify the state of Washington, hey, there's this asset out here. Come get it. And if they do and they marshal it forward and they get it sold and some random relative shows up, that relative gets 7 years from when the state does that, gets 7 years to make their claim. If 7 years comes and goes and nobody did anything about it, then that's the end of it. And we all get to enjoy that money as residents of the state of Washington. It goes into the school fund.
Well, I do have a background in grants and foundations, and so that's why I thought of a foundation in the name of,
Yeah.
yeah,
It would work if the person was alive, they could do what they wanted, but if they've passed
Yeah.
away, there's nobody.
oh, that's
Wow.
sad. Patty,
Yeah.
thank you for your question. I know, she's again, we're looking at big heart, right, Andrea? So there's all kinds of properties and situations that come up. And sometimes that's another reason that all of us should put something together or encourage our family and friends to go ahead and get their estate planning done earlier than waiting until somebody gets sick or passes. I think we got through most of the questions, Andrea. On Form 17,
That's a big one. I have a
Yeah.
couple opinions on that one, just
okay. Do you mind staying a little bit longer to answer that question?
totally fine. So Form 17, if it's a personal representative, so if it's being sold out of the estate, it's personal representative, they do not have to fill out the Form 17. They can, if they choose to, but why would you take that liability on? It's not required. If it's being sold in some other form, so it's a trust that's selling the property, power of attorney, attorney in fact is the one selling it. Those people have to fill out the Form 17. It's only in the context of the personal representative. So when it's being sold by the estate itself, or it's being sold like in a judicial foreclosure or that other sort of process. But for what you guys are going to probably run into, it's going to be an estate. That does not mean a trust estate. It just means like a probate estate.
Okay.
And it is okay if the person genuinely doesn't know. If we've got, person whose property it was, they pass away, it's owned by the trust, the kids come in or whoever comes in and the answer is really, I don't know. They can say, I don't know.
Okay, very good. And then what if one, like say the spouse dies, so, they're not exempt because it's not an estate. It reverted to say the wife is still living. The wife would then fill out the Form 17, correct? And then the husband was obviously dead. So,
Yeah, very likely, that's what would happen. And typically, yeah, if that person who's still alive, has an ownership or has a connection to that property and it's being sold, it kind of is joint property, then yes. If it's a scenario where the property was, and this comes up, if the property was only owned by the spouse that passed away and the surviving spouse had no ownership of that property comes up in later marriages, right? They don't always own all the property together. Then in that scenario where it's being sold out of the estate and the surviving spouse has no actual ownership of the property, then they can just say personal representative status, no Form 17.
Gotcha. Okay. That's helpful. Thank you so much for answering the question on that. I think that's a wrap. So Shannon, was there any questions that came into you? I know you field a lot of the questions. So was there anything more that needed to be covered?
No, I know we're limited on time, so I suppose if those that had other questions, Andrea, I'm sure you've got your contact information that we can slip their way, and they can reach out to you if they've got further questions there.
Yep, that would be fine. You can reach out to me. If it's something that, obviously I can't really advise on a specific thing until I'm officially hired to do the job and all of that. But happy to field a few questions. Another thing I wanted to let you guys know, I assume, Rachelle, are you going to share my contact information, my email and everything?
Yeah, you have the last page too. So if you want to flip to the last page, it's already on the screen. We could throw that on there. That would be great. We got our own examples, but I appreciate you having the examples because sometimes you never know. They don't have questions.
Yeah, exactly. I
That's
like
good.
to have real life examples. I'm happy if anybody wants to shoot me an email and just say, I was at the Best Choice luncheon or the Best Choice event. I'm going to be starting up a newsletter on, I don't know if it's going to be quarterly or monthly, but I'm starting up a newsletter. If you want to be part of my email list, you can send me an email just with that line. So I will add you into that list.
I know my clients are aging, Andrea, so definitely want to make sure I get on the list too. So
that sounds great. I'll put you down now.
awesome. Super. Well, you guys have a good afternoon. Thank you so much, Andrea, for the great information and awesome presentation. Hopefully that was helpful for some of you that had questions about estate planning and just in general, when people death and die. I told her, I said 1 hour. It's hard to keep it to 1 hour, but you did a great job. Appreciate
Thank you very much. Thank you,
All right.
everybody, for your time.
Have
this
a good
afternoon.
one.
Take care.
Thanks.